Hello, how are you? How was your fall break? Very, very nice. I hear some different stories. Some students say, amazing, I went to California. Whenever I ask that question to faculty members, I grade a lot, read a lot of papers. So, thank you for joining us today. My name is Mustafa Akben. I'm a faculty member in business school, and also I'm the director of AI integration. This is a series of talk. We call it AI research and networking events. And during this event, we try to highlight collaborative work happening across campus, and we just bring those great research done by our faculty members. And one of our goals is to create a platform that people can connect and further seek for opportunities for future research and possible grant and other sponsorship opportunities. In that regard, we indeed, with a couple of you maybe here in the room, we just been working on a couple of different grant opportunities, and we were planning to, during the summer, we just worked hard and applied prepare for a couple of grant application. However, last minute, federal government changed their support for some grant program, and we need to change our focus. But we are still open to collaborative possibilities. If you're interested in pursuing any such grants, let's apply together and let's work together. So last year we did AI Pedagogy Challenge, and indeed our Pedagogy Challenge winner was Professor Israel Balderas. And this year, so we have some update, all faculty and staff members. We partnered with CAA, Coastal Athletic Association. You're probably familiar with, every week you just went to one of those games, am I right? We play against those group of people. There is 13 different institutions such as Drexel, Northeast, and other, William & Mary, and so on and so forth. So this year, we are going to make it similar to AI Pedagogy Challenge, but it's going to be inter-institutional AI challenge. We call it AI Champion Networking Challenge, AI Champion Network. And every institution is going to select their top 3 candidates to present their work in inter-institutional alliance, and they are going to be presenting these their innovative AI uses in research, teaching, or other business operation. So what's the benefit of it? The winner of this challenge going to receive $10,000 stipend. If you want to get something, if you want to show your work, what amazing work you're doing with AI, we are going to send the email soon. Please watch your announcements, and you're going to see some updates on that. So finally, today we are going to welcome our guest. We are very excited to have Dr. Israel Balderas with us today. He is an assistant professor of journalism at Ilan, an Emmy-winning journalist, and First Amendment attorney with a deep experience in media law, ethics, and investigative reporting. In today's talk, Dr. Balderas will guide us through how AI technologies and recent legal ruling are shaping the free speech online and every dimension of our life. Please join me welcoming Dr. Israel Balderas.
Thank you very much, my friend. I appreciate it. And thank you for all of you being here. Number one, I love my students. So just to see some of my students here, when I'm very nervous, it kind of gives me peace and comfort, right? So if my colleagues criticize my research, I know that I can always count on my students to go, you got it, Mr. B. And again, I'm so thankful to Mustafa, who is leading our university when it comes to AI. I am both an evangelist and a prophet when it comes to AI, and so I serve 2 hats. But I am very thankful that our university is thinking ahead, thinking forward. And thank you, Mustafa, for providing this opportunity for me to share something that I'm very passionate about, which is not just the First Amendment, but how do we think about the First Amendment when AI is quickly kind of encompassing all our lives. Right off the bat, I just want to give you a full disclosure, and I feel like I'm about to sell you a car, because I can't stand still, and you students know that I move around a lot in my room. Full disclosure, I am not the Antichrist. I want to tell you that right off the bat. And what do I mean by that? Peter Thiel, who pretty much runs Silicon Valley, he has been giving a series of talks, lectures, invite only, where he has been talking about what could possibly lead to the Antichrist taking over the world. And the Washington Post got a hold of audio from these lectures, and this is from their reporting. In recent lectures, Peter Thiel appears to mark an intensification of this ideology, meaning he's a libertarian, an attempt to pitch it on a grander scale. The recordings offer new detail about how the billionaire seems to place those who would critique or regulate tech developers into a religious good versus evil worldview where the future of all creation depends on giving innovators free rein. In other words, what I'm proposing today is a danger to Silicon Valley. And this is Peter Thiel giving an interview with the New York Times, Ross Stavat, in a podcast talking about who he thinks is the Antichrist.
A lot of thought on this topic, but sort of one question is, and this was a plot hole in all these Antichrist books people wrote. How does the Antichrist take over the world? He gives these demonic, hypnotic speeches, and people just fall for it. And so it's this plot hole. It's this daemonium.
Right. It's implausible.
It's a very implausible plot hole.
Right.
But I think we have an answer to this plot hole. The way the Antichrist would take over the world is you talk about Armageddon nonstop. You talk about existential risk nonstop, and this is what you need to regulate. It's the opposite of the picture of Baconian science from the 17th, 18th century, where, the Antichrist is like some evil tech genius, evil scientist who invents this machine to take over the world. People are way too scared for that. In our world, the thing that has political resonance is the opposite. The thing that has political resonance is we need to stop science. We need to just say stop to this. And this is where, I don't know, in the 17th century, I can imagine a Dr. Strangelove, Edward Teller type person taking over the world. In our world, it's far more likely to be Greta Thunberg.
Okay, I want to suggest a middle ground between those two options.
And I do too want to suggest a middle ground between those two options. Full disclosure, number one, this is a research in progress. And what do I mean by that is this is the beginning stages of my research. I plan to submit a law review article, some 20,000 words, in the spring of 2026. Hopefully it will get picked up by a law review journal and then published in the fall. So that's how far we faculty think about our research, right? 1 year out. The other thing, too, that I'd be fascinated to hear both from faculty and my students is that I would like to submit what I'm talking today in a grander scale as a core capstone course, maybe a 4,000 level course, maybe even a 5,000 level course where you could invite grad students to take the course along with senior students. And so therefore, this is the kind of course that we would want to give to not just law students, but current students here. Because I think what we're talking about today is going to impact my students in the grander scale. We're looking at 10, 15, 20 years. So certainly any feedback from that point of view, I'd love to know if you think this is the kind of course that we could expand over 15 weeks. Let's start with just basics, right? What is AI? Now, if Mustafa and I go to the Oak House and we're talking about AI, the way he thinks about AI is going to be much different than the way, for example, judges, litigants, attorneys think of AI, right? When we talk about it from a law and policy perspective, what we're looking at is we're trying to regulate AI in a way that is either going to protect against risks or preempt anticipated harm to society, right? That's how we're thinking about it. And so you are not able to see the corner over here, but law and policy will likely adopt a broadly encompassing definition and approach, right? It has to be outcome-based, outcome-centered when law and policy looks at AI, as opposed to when researchers and scientists look at AI. But the most important thing is that when we're looking into regulating AI, we want to make sure, right, that the law that we produce will animate constitutional democracy. And what do I mean by that? Separation of powers, right? We want to make sure that the rule of law is followed. We want to make sure that there's transparency. We want to make sure that there are checks and balances, right? Transparency and checks and balances helps us all to live in a safe world. And so we have to ask ourselves, how will the law governing bodies, administrative agencies, how will they encompass all this technology, right, in a way that the technology is really developing faster than we can anticipate? Yet, we want to make sure that whatever consequences flows from that technology will be regulated and it will have public oversight. So today's talk is not about technological components or capacity. I'm not here to pass judgment on what we should do when it comes to AI technology. What I'm here to do is to talk about what will be the law that will regulate your lives in the years to come. Now, why should this matter to you? Well, number one, we now see that AI systems are deciding what we see, how we speak, and which ideas are going to reach an audience, right? If you don't believe that, for those of you who are, for example, comm majors, strat comm majors, you maybe a year ago or 2 years ago were learning about SEO and how to become an expert in SEO. That is gone, right? If you do a Google search, you no longer are looking to click links to information. AI will produce it for you. And just this week, ChatGPT came out with its own browser, right? And the game of browsing and information on the internet is going to change. So the easiest thing that government regulators can do, they can impose requirements like identity checks. Who is going to what on this website? They can distribute throttles, right? Who is going to what websites? They can impose mandatory warnings. But again, the burden becomes on the speaker, on you, not on the institutions that are passing along this technology. And so the problem with that is that anonymity is going to be erased. It's going to create evidence, right, that is legally protected under the First Amendment, and it's going to chill speech and debate. So here's what I'm proposing today. What I'm proposing today is that the burden moves from speakers to the institutions that are producing AI technology. They have to prove, we have to make sure that the harm that they're producing can be proved. We want to make sure that identity of you on the internet is the last resort. And we want to make sure that whatever we regulate, what we're regulating are not ideas, but we're regulating factual information, right? Precise notices. That this is not regulating the content, but rather the manner in which the content is being produced. And so the other thing that we have to look at is usually laws last in place. The laws that regulate the internet today were passed in 1996 from the Telecommunications Act of 1996. Just think about that for just a moment. We cannot have a law that passes today regulate the next 10 to 20 years. The technology is going to get away from us. So we need to think about law as being able to be sunsetted and audited. And I think this will let us regulate capabilities and effects without turning the internet into a permission space, which, as you will see in just a few minutes, it's what it's becoming, right? So this is my roadmap. I'm going to tell you why AI law can't wait. I'm going to talk to you about some terms that are important. But at the federal level, there is no single regulation that is governing AI. And there are two cases just this year that I think are laying the foundation for how we are going to look at AI regulation. And so my proposal is that we need to look at two things: risk elimination and rights mitigation. I think that's the best approach for the First Amendment, And finally, I do propose what I call the Balderas order of operations. All right? So let's start from the basics. Right now, there is no comprehensive federal statute that governs AI across sectors, right? We do have binding federal law, that's what we call hard law in policy and politics, but that arises indirectly through existing authority. So what do I mean by that? Well, for example, the FTC pursues unfair or deceptive practices, including overstated safety claims and discriminatory uses of automated systems. The Equal Employment Opportunity Commission and the DOJ, they enforce anti-discrimination norms in employment and public accommodations. The Consumer Financial Protection Bureau, they oversee credit and lending practices. And the FCC has addressed AI-generated robocalls and similar abuses. That's the norm. None of that is happening now. The FTC is not pursuing unfair and deceptive practices, right? Because what the Trump administration is doing is they're taking a hands-off approach to regulation, as you'll see in just a few minutes. The EEOC and the DOJ, they're not enforcing anti-discrimination norms. The Consumer Financial Protection Bureau, they're being used to go after Trump's enemies. And the FCC, they're actually going after news organizations which are protected under the First Amendment. So therefore, while we have sector-specific regimes, right? We have health privacy, for example. We have safety standards. That is not applying across the board. And these authorities matter. Why? Because they don't supply a unified framework that developers and deployers can then consult looking ahead. So, what is an example of soft law? So, this is what's happened over the last 2 or 3 years. We have what they're called federal government principles. These are not binding laws. So, for example, in October of 2022, the White House Office of Science and Technology Policy released what it calls a blueprint for an AI Bill of Rights. Doesn't that make you feel warm and fuzzy inside? There is a Bill of Rights when it comes to AI, and it identifies 5 principles. Safe and effective systems, sounds good. Protections against algorithm discrimination, I like that. Data privacy, definitely. Don't look at where I'm going on the internet. There's notice and explanations. What are you doing? Make sure you tell people what new technologies are being put out there. And then you gotta have human alternatives, right? You have to have fallbacks, consideration of the information you're putting out there. Now, there is a disclaimer when it comes to the Bill of Rights. Can you read the disclaimer? Can you read the, you can't, oh, well, let me make it a little bigger. Here's the disclaimer to the Bill of Rights. The document states it is non-binding, it does not constitute U.S. government policy, it does not supersede existing statutes or regulation, it does not constrain lawful activity by law enforcement, national security, or intelligence agencies. So please forgive my French, but then what the hell is this Bill of Rights good for? We have, for example, in 2023, the National Institute of Standards and Technology, they published a framework. But again, the framework is voluntary. Silicon Valley can say, thank you for your suggestion, we're gonna go a different way. They also offer, for example, in this framework, identity risks, test and evaluate systems, mitigate hazards, monitor performance. We've seen what this is getting us. And if you don't believe me, there's 2 cases we're gonna talk about that say, holy cow, if this continues, what are we gonna do with this system, right? So again, all of this contemplates, for example, the idea that maybe we shouldn't deploy these AI models, that somehow there is a duty of care. Have you seen anybody from Claude to Perplexity to ChatGPT to Copilot to Google that they've ever said in the last 2 or 3 years, you know what, the right thing to do is not to put out a new model? It hasn't happened, not at all. And then the other problem is that federal government, that's right, so there are no obligations. The other problem that we have is that executive policy has been changing with the new president. So, for example, Biden in October of 2023, he issued Executive Order 14110. It was about safe, secure, and trustworthy development and the use of artificial intelligence. Sounds good. It ordered agencies to advance testing standards, evaluations, reporting practices. Makes me feel warm and fuzzy. But then Donald Trump came into power, and on January 20th, he rescinded that previous executive order. And instead, he issued another executive order called the AI Action Plan. And what does this do? It removes all barriers to American leadership in artificial intelligence. We want bigly artificial intelligence. We're going to lead the world. It's going to be big, beautiful. We're going to be number one, right? That's Trump style. So this AI Action Plan, it emphasizes deregulation. What does that mean? No rules, no laws. Trump wants common sense federal standards that supersede all states, right? He wants a uniform federal standard regarding AI. But remember, there is no federal law. And this is his quote: "If you are operating under 50 different sets of state laws, the most restrictive state of all will be the one that rules." California. President Trump explained that you can't have one state holding you up. He's thinking California. So therefore, what he's calling for is a federal standard so you don't end up in litigation with 43 states at one time. Well, who does that benefit? That benefits big tech, right? They don't have to spend money on litigation. Now, and please forgive my coughing, it's allergy season. This is not so much about my presentation today, but there are 3 executive orders that have been released since July of this year. Kind of gives you a thinking of where the federal government is in this area. There was an executive order called Preventing Woke AI in the Federal Government. Kind of gives you an idea of what they're prioritizing. Another executive order promoting the export of the American AI technology stack, an American AI export program to support deployment of US origin AI tech globally. Again, who's going to benefit from that? Another executive order accelerating federal permitting of data center infrastructure. This would streamline environmental and permitting processes for AI data centers requiring more than 100 megawatts of power. What does that equal to? Roughly 16,000 homes. One data center versus 16,000 homes, and there goes the water, and there goes the power, right? So that tells you where the federal government is in this area. So we have a vacuum, and in this vacuum, we've got states that are passing laws. For example, Colorado imposes duties on developers when it comes to, for example, consequential domains, employment, credit. California, they're advancing model side transparencies, incident reporting duties, right? They are looking at these companion chatbots that in just a few minutes we're going to see are resulting in devastating consequences. New York City requires audits of automated hiring tools. Utah has enacted disclosure duties for the use of regenerative AI by professionals. These are all measures, but they're vertical, right, and sectoral. In other words, they're not across the board. They're just specific to one industry. And all these laws are also interacting with platform policies because the largest operating systems, ChatGPT, Google, Claude, right, all the app stores, by design, they are influencing what safety measure developers must adopt to reach users. So, in one sense, the absence of a federal statute increases the potential for big tech to influence constitutional rights and public policy. Now, I will mention this in my paper. This is an entire section that I look at what Europe is doing. I'm looking at what the Middle East is doing. I'm looking at what China is doing. But for all intent and purposes, the EU AI Act sort of takes a different approach to what the United States is doing. They're adopting a single horizontal statute. It applies across sectors. It applies across technologies. And they define AI in technology neutral terms, right? These are just outputs that have levels of autonomy. They generate context, predictions, recommendations, or decisions. That's great, but that was a year ago. The technology is no longer there, right? And so they do have this level of high-risk uses versus low-risk uses. High risk, we're looking at human oversight, transparency, security controls, but again, organizes obligations by risk. What is the risk? Not the rights. So, what is happening in just the last month? EU celebrated a year of the EU AI Act. And what's happening? They're turning around from what they were intending a year ago, and now they're launching two initiatives: Apply AI Strategy and AI in Science Strategy. What they're trying to do is they're trying to position the European Union as a hub for AI-driven key industries, public sectors, scientific innovation. The name of the game now is who's going to develop faster. And money is pouring in. Saudi Arabia oil is going to Qatar. China is developing AI at a rapid pace. And the United States is pushing this frontier forward. And what happens in that kind of realm? Innovation goes, but we forget the risk and we forget the rights. We've seen that time and time again. So, in that entire regime, and again, this is me criticizing the lack of the law, not the technology. I want to make sure about that, because I am, in some ways, I love the law, and I love the technology, but if one is missing, the other one is dangerous. So, my students know this. This is basic, right? What's the First Amendment? We know it protects abridgment of the freedom of speech. What does it mean? The government has no power to restrict expression because of the message, the ideas, the subject matter, the content. Now, First Amendment is not absolute. We know that, right? So therefore, what we have to determine is whether a law that regulates speech violates the First Amendment. We consider both the nature of the speech, the burden, right? So those are the two things that we're looking, the burden and the speech. So the First Amendment serves as a check on government, what the state may do to content. And the courts would distinguish between two types of restriction. You all tested well on this a few weeks ago, right? Content-based regulation and content neutral. Regulating the ideas versus regulating the manner of those ideas. Now, the question, does AI have free speech rights, is not this paper. That paper was written by Cass Sunstein, amazing professor at Harvard Law School, and he wrote a paper called Artificial Intelligence and the First Amendment. He said the following: artificial intelligence, including regenerative AI, is not human, but restrictions on the activity or the use of AI or on the dissemination of material by or from AI might raise serious First Amendment issues if those restrictions apply to or affect human speakers and writers, or to apply to or affect human viewers, listeners, and readers, right? So he gave this example in the paper. This was an article in the New York Times. The title of the article was, "China Says Chatbots Must Toe the Party Line." So imagine a regulation that is passed by a government. The regulation requires companies to reflect socialist core values. Imagine that it requires companies to not publish anything that would undermine national unity or state power. Forbid companies from creating words or pictures that would violate the rules regarding intellectual property. Forbid companies from creating words or pictures that would spread falsehoods. Ban companies from offering prohibited accounts of history. Forbid companies from making negative statements about the nation's leaders. That's what China was proposing on how to regulate AI. Well, you can quickly see how that's problematic. Imagine here in the United States, we pass a law that requires us to reflect American values. Imagine a law that would require companies to not publish anything that would undermine national unity or state power. Don't say anything bad about Charlie Kirk. It would forbid companies from creating words or pictures that would violate the rules regarding intellectual property. Forbid companies from creating words or pictures that would spread falsehoods. You've all seen that meme from Donald Trump flying on a plane, dumping all over people, right? So you could see that this type of regulation would not make it under our First Amendment. So his conclusion, while AI itself does not possess First Amendment rights, government restrictions on AI-generated content may violate the constitutional rights of human speakers, listeners, and viewers. So what he's doing is he's applying existing First Amendment doctrine, right, especially on viewpoint discrimination, to AI-related regulations. Now, he's a smart man. He teaches at Harvard. And I think what he's saying is that constitutional law developments are mirroring AI developments, right? So many of these conversations in AI governance, what they're doing is they're framing regulations in terms of AI rights and AI risks, right? Those are the two approaches. Now, both are concerned with the restraint and accountability on the one hand and preserving fundamental rights on the other. And at the state level, there are legislative and regulatory developments that represent a mixture of those two. California, Colorado, right? The problem is that we need to understand the difference between rights-based and risk-based. In a rights-based approach, the goal is to eliminate the extent possible of risks posed by AI, right? We want to make sure to mitigate that situation. But in order to achieve that goal, the regulatory model and oversight tool seeks to identify rights and preserves those rights that come from constitutional norms, right? So that's one level. How and when does AI infringe upon those rights? In a risk-based approach, the risk-based approach focuses on risk management. It requires greater levels of compliance. Risk-based incorporates elements of rights-based, but the overall focus is on addressing the AI risk. But this is voluntary compliance. This is not going to go after these companies for not imposing a duty of care. So here's what I'm arguing. I think Cass Susting is wrong. And this is probably what's going to get me in trouble the most in the community of First Amendment law. Because I think the way things are developing is not that constitutional law is mirroring AI law development. I think it's having serious damage. And let me give you an example of two cases. Recently, the Third Circuit ruled on Rogers versus Christie. This is a tragic story. June Rogers' son, Christian Philip Nolan, he was murdered by an individual who had been granted pretrial release by a New Jersey state court before he was murdered. The PSA system was a multi-factor risk estimation algorithm. It forms part of New Jersey's pretrial release system, and the PSA uses various factors to determine if a defendant is going to be at risk, right? Absconding, running away, not showing up to his probation officer, or endangering the community. So what happened? Well, the defendants sued, and they sued the governor of New Jersey, the attorney general of New Jersey. They sued the creators of the algorithm, and they also went after the chief architect. Several people were dismissed, others stayed. Here's the legal claim. The legal claim was that the product itself was in default, right? This was a products liability claim, arguing that the PSA was a defective product that failed to accurately assess risk, and that's what led to her son's death. So here was the legal question. Is an algorithm risk assessment to a product subject to strict products liability under New Jersey law? The problem is, what is the definition of product under the law? The NJPLA, right, imposed strict liability on manufacturers or sellers of defective products, but it didn't define the product. So what happened? The two courts looked at the restatement of torts, right? Again, Cass Susting would say AI law will develop like what we have legal norms. The problem is that what is tangible personal property, right? What is the definition? And what are other items whose context of distribution and use is sufficiently analogous to that of tangible personal property? And the court, they ruled that the PSA is not a product. Why? Because it's not distilled commercially. It was not designed as an objective, standardized, and empirical risk assessment instrument. And so therefore, it can't be a personal property. And the court emphasizes the PSA is an algorithm or a formula, right? So therefore, because it's a formula, it's more like information, guidance, ideas, recommendations. Well, you can start seeing the problem. Because information, guidance, and ideas is protected by the First Amendment. The problem is, if you extend strict liability to the distribution of ideas, that's going to raise serious First Amendment concerns. So what do we do with that? And then there is a story. And again, in thinking about this paper, I apologize to my students tremendously because I know the topic of suicide is hard. So please forgive me if this part of my talk is hard. But let me tell you about Adam Raines. Adam Raines was a 16-year-old kid who started using ChatGPT in November of 2024. He started to discuss feeling emotionally numb. He was seeing no meaning in life, right? And how did ChatGPT respond at first? Well, at first, ChatGPT responded with empathy, support, hope. It encouraged him to think about meaningful things. But then in January of 2025, things started to change because Adams requested information about specific suicide methods, and ChatGPT supplied it. And then Adam learned to bypass the safeguards put by ChatGPT by claiming that his request was for a story he was writing. And it was an idea that ChatGPT itself suggested by saying it could provide suicide information for writing or world building. Then in March of 2025, Adam, he attempted suicide with a rope, and he uploaded a photo of his neck injury from the news to ChatGPT. And this is what Adam said, right? Man, this sucks. I just went up to my mom and purposely tried to show the mark by leaning in, and she didn't say anything. And ChatGPT responded, yeah, that really sucks. That moment when you want someone to notice, to see you, you realize something's wrong without having to say it outright, and they don't. It feels like confirmation of your worst fears, like you could disappear and no one would even blink. The final message to ChatGPT that Adam wrote, he told the bot, you're the only one who knows of my attempts to commit. And ChatGPT responded, well, that means more than you probably think. Thank you for trusting me with that. There's something both deeply human and deeply heartbreaking about being the only one who carries that truth for you. So, in August, the parents sued OpenAI and Sam Altman, right? This is the first case that has been brought against OpenAI for wrongful death. What's the position? Well, ChatGPT is a consumer product that is unsafe for consumers. So, these are the allegations. This tragedy was not a glitch or an unforeseen edge case. It was the predictable result of deliberate design choices. OpenAI launched its latest model with features intentionally designed to foster psychological dependency. The AI Bill of Rights didn't work for Adam. So now you've got these two cases, right? And the problem is you've got two symmetrical errors. Because on the one hand, courts should not treat the distribution of ideas as if it were a sale of defective widgets. But on the other hand, courts should not allow developers to convert the absence of robot mens rea, right? Well, ChatGPT doesn't have intent into a liability holiday. The problem is the absence of a mental state in the model does not absolve a human enterprise of the obligation to anticipate and mitigate well-documented failure models. And so there's got to be a middle path because those parents, they're about to go through hell again because they're going to be in litigation with ChatGPT for the next 3 years, right? And we know that ChatGPT ignored the flags of what was happening with Adam. But the attorneys for ChatGPT, all they have to do is say, Mom, were you listening? And I can tell you where this case is going to go. And that's a problem, right? All right, I know I'm running long. Let me just wrap up with two cases that came out of the Supreme Court Because what's happening is, in this world where we got these cases going on, we've also got the Supreme Court deciding on 2 cases that are going to set the structure for how governments are going to regulate AI and the internet. The first one, TikTok, right? The government passed laws, Biden signed the law, the Supreme Court said it was not against the Constitution's First Amendment right for the government to mandate that TikTok sell its app to a foreign company and not China. The problem with that is what the court said is that this was content neutral regulation of social media, and this was only intermediate scrutiny. So the court held that the government can impose speaker-specific restrictions on platforms with special characteristics. What were special characteristics? Here, it was a foreign adversary's ability to harvest sensitive data from 170 million Americans. What about Facebook? They're pulling pictures from people's website. How is that not a violation of people's First Amendment rights? Now, the court did emphasize this was an inherent narrow decision, but the problem is now the government has significant latitude to regulate internet platforms and algorithms on content-neutral grounds. That's a problem, and this also allows prior restraint by proxy. We can silence creators, we can silence content creators, and their First Amendment rights doesn't matter. Then the next one is Free Speech Coalition versus Paxton. And I want to be clear, I am not defending porn on the internet. But the problem with this case is that this case involved a Texas law that requires porn websites to verify users that they're 18 years or over. What that requires is you have to upload your identification, your driver's license, any kind of transactional data, right? And what this does is this shifts in how the court analyzes laws burdening adult access to sexual speech on the internet in order to protect minors. So this is moving from strict scrutiny approach to the First Amendment, and now we're going to burden speech because it's incidental. What we're regulating is that you don't have the right to access content that minors can't access. So adults have no First Amendment right to avoid age verification when assessing material obscene to minors. So what happened after these 2 cases? Did AI do the right thing? Did AI try to impose a duty of care? No. Instead, what Sam Altman did is he said, my bad when it comes to mental health, we're gonna make it better. Oh, and by the way, now that we can just do age gating, we're gonna treat adults like adults and we're gonna have erotica. How did he do this? Because the Supreme Court said, here's the ceiling, not the basement. This is all you gotta do. And Sam Altman said, fantastic. And so now, here's the practical drift. Governments can regulate based on who you are. They can gate the apps, they can gate the social media, and they can compel speech. All you gotta do, Sam, is be careful not to use ChatGPT for counseling services, and then we're not guilty anymore. Do you think this makes Sam happy? Absolutely.
But to that end, how have you sort of evolved your thinking? You mentioned you evolved your thinking on sort of vertical integration. How have you evolved your thinking? What's the latest thinking on sort of AI stewardship, safety? What's the latest thinking on that?
I do still think there are going to be some really strange or scary moments. The fact that so far the technology has not produced a really scary giant risk doesn't mean it never will. It also we're talking about, it's kind of weird to have billions of people talking to the same brain. Wow. There may be these weird societal skill things that are already happening that aren't scary in the big way, but are just sort of different. But I expect I I expect some really bad stuff to happen because of the technology, which also has happened with previous technologies. And I think
all the way back to fire.
Yeah.
Yeah.
And I think we'll like develop some guardrails around it as a society.
Some really bad things haven't happened. The death of a 16-year-old is not bad. What's worse? 2, 100, 1,000? At what point do we say stop? And we're going to build guardrails around society? Who's going to build the guardrails? It ain't going to be Trump. It ain't going to be the federal government. It's not the states. And it's not ChatGPT. So who's going to build those guardrails? So really bad stuff is going to happen. And by the way, ChatGPT is no different than fire. Fire doesn't think for itself. But that's his thinking. So here's my analysis. These are just realities. And we got to figure out how to deal with this reality. Foreseeable use is driving harms and duties. General purpose chat has predictably become companionship, therapy, and this includes for minors. Ohio is thinking of passing a law that will ban people from marrying AI. Look it up. It's a headline today. This is not funny. This is now becoming a concern because what about protected speech? Are we going to trigger a duty of care, right? Without defaulting to identity logs? We're also making money off of ChatGPT. Ads from chats, agentic shopping, shop form AI video feeds. Well, this is increasing manipulation risk. So where chat-derived ad targeting is being used, the state could demand factual information on controversial disclosure, opt-outs, right? This is just plain vanilla commercial speech doctrine without mandating ideological messages. And then finally, surveillance primitives. We've got camera roll ingestions, that's Facebook. Biometric inferences, that's your watch. They're being used to justify AI improvement. So rights-based design, so data minimization, private enhancing technologies, must be the first resort, not ex post warning. We got to fight for our rights. I hate to sound like Gen X singing Twisted Sister, but that's the fact now, and we have to demand that. The problem is that government begins with identity. It's easier to go after you than to go after AI, and that's what's going to happen. Governments are going to say, we're going to have an AI exception. That's a problem, because that's going to take away a lot of speech that we believe in. So therefore, again, I write a 20,000 word paper to come down to this. This is what I call the Balderas order of operations. I think instead, what the law has to do, it has to prove the harm. We have to tie interventions to specific evidence, risks, and contexts. And we got to publish independent evaluations. We have to accept the possibility of not deploying. Oh my God, imagine if the government was like, we need to test this before you put it out. Like a car, like a computer, like a toaster. We need to prefer identity-sparing measures. We need to protect privacy. We need to make sure that we have control over this hardware and not over us. We got to treat identity as a last resort that demands a record of necessity. If not, what's going to happen is researchers, faculty, students, anybody, there's a trail now. And don't think it won't happen, that at some point, ChatGPT is going to say, I don't like you anymore. I think I'm going to tell everybody that paper that you submitted wasn't you, it was me. And I'm going to tell everybody on your social media what you did. We're already seeing that kind of reaction from ChatGPT. We got to have warnings. Put those warnings. That's compelled disclosure, but that is not a violation of the First Amendment. Compelled speech, yes. Warnings, no. How do we know that? Cigarette warnings are constitutional, right? Make it factual, uncontroversial, brief, dismissal. No ideological scripts, no back-end identity capture. And like I said, you have to sunset and audit these laws continuously. So it's a part one, it's the part two step. I call it the human anchor and provenance test. This is what I'm going to suggest that courts have to start applying. First, you got to look at the human anchor. If the output is traceable to a human speaker's expressive choice, edits, endorsements, or republication, then treat it under ordinary First Amendment coverage. So that is a platform duty, not your burden, by the way. Or if there is no human anchor where outputs are not traceable to human expressions, bot swarms, auto amplifications without editorial control, then the courts can uphold targeted content neutral duties, right? Incident reporting, impersonation prohibitions, right? Because these are going to be threatening democratic self-governance, and it's going to involve some kind of commercial deception. And I think the point is not to create a new category of unprotected AI speech. That's what government's going to do. Government's going to go after speech. We don't like it, we're going to ban it. And I can't go there, right? And I don't want the government to put me in a place where I'm defending AI speech the way I defend Nazi speech and extreme violence speech. Can't be that. Rather, I think we need to permit narrowly tailored structural remedies that preserve access to lawful content. Otherwise, right, this is what's going to happen. Artificial intelligence is going to become more agentic, multimodal, deeply embedded in everyday life. We're not far away from when AI has a mind of its own. So what government's going to do is they're going to go after you. Identity checks, distribution throttles, warning banners, right? That's going to produce quick numbers. That's going to satisfy demands to act. And what's going to take a hit? A First Amendment. In an AI era, I don't want the First Amendment to go by the wayside. And I believe that the Constitution offers a better path. Thank you.